Judy Wineburger versus Chelsea Cotterman. Bing, bing. And they're off.
Good afternoon, Your Honor. It's Chelsea Cotterman.
I'm here also, Your Honor, Judy Wineburger, and my attorney is Mr. Taylor, and he's here representing me.
Okay, he usually can enter his own appearance, but I'll let you go. Mr. Taylor, I'm not hearing you. So it might be that you're not quite connected to audio, sir. Still can't, nothing. Then he left. Okay, he'll sign back in. I'll pass this matter briefly. Mr. Taylor back?
Yes, I'm here.
Oh,
sorry about that. Yes.
Oh, not a problem. Court recalls the case of Wineburger versus Cotterman.
Edward Taylor appearing on behalf of Ms. Weinberg, 57166.
All right.
I'm also here.
I know. All right. Where are we on this case? The last I left you folks, there was supposed to be a plumber coming in and something.
I still don't have water, Your Honor. She came in and turned it back off.
Your Honor, the lease is over and Mrs. Weinberg like possession of her property, Your Honor.
Okay, so what happened with
application submitted, and she said that I do not live here, and I am currently still residing in my presence and have been.
Okay, first thing is this. What happened to the water?
I can answer that.
Go for it.
At the last meeting, you told us we had permission to take the plumber over there and find out how we can fix it. And I did that. And what we have to do to fix the water is dismantle the bathroom and work on the plumbing and take the flooring out and repair all the damage. And to do that, she can't be in the house because the bathroom will become totally unusable.
So are you supplying her a place to live?
I did try to do that and she refused. I offered her a week stay at a hotel so I could repair the water, and I offered her a taxi cab ride there, and she refused that offer and refused to leave.
Your Honor, she tried to get a hotel room an hour away from where I live, and I currently work and take care of my mother. So when I tried to correspond back with her, and she just did not respond at all to my emails.
Where was the hotel?
The hotel. No, it was right at the airport.
In Romulus.
Wait, what? There are plenty of hotels in Ypsi, Ann Arbor. Why are you sending her out to the airport?
Because it was an emergency on a holiday, sir. It was an emergency on Memorial Weekend, and most of the rooms were already full. And I tried to get one, and that was the quickest one I could get.
Excuse me, Your Honor. I have filed a complaint with the Michigan Department of Attorney General back April 15, 2020, and I had the complaint number available, and she has not responded. So she knew there was a filed complaint, and she did not acknowledge it until something happened to the lower department or whatever, 3 months later.
Okay, so people, what do you want me to do?
What I'm asking for is possession of my house so I can repair it. The lease ended June 30th.
And I have a Sarah application that has been submitted, and she told them that I do not live here when I had had been living here the whole time. And my DTE bill is attached to my Sarah application.
Sir, that's not exactly true. Sarah contacted me and I explained what had happened, that I had given her the money, and they refused to accept it.
And I have not taken any money. That's fraud.
For what money?
She tried to buy me out of my lease with a ceremony, and I refused.
That's right.
In January.
Okay, well, but you can't. Man, the ceremony was paid to you. You can't give the ceremony.
We already discussed that when I was here before, and 4 more months have passed and she has not paid any rent. Her lease is now over and I simply want her to leave so I can fix the house and turn the water on.
Well, I'm going to tell you what. Since you tell me what you want, you got to turn that water back on and you got to give her a place to be that's reasonable around the area that she is.
Why?
You can't evict a tenant by having a condition that exists that interferes with their ability to stay in the unit. It can't happen.
She has stayed in the unit since the end of May with no water.
Ma'am, you want to argue with me or you want me just to order it?
I'm not sure what you're ordering.
Oh.
I believe this is all retaliation, Your Honor.
Counsel, you better get Mr. Taylor.
Yes, sir.
I'm going to pass this matter. You better get your client in check.
Very well.
Because right now, I'm going to tell you, she is interfering with this tenant's tenancy, and I can start finding her $200 a day under the statute, and I can make that retroactive because she hasn't supplied the utilities. So if I add that up right now, if she wants me to order it, if she wants to challenge me on what I can order,
no,
then
Your Honor,
she needs to understand that I can order up to about $8,000 right now.
This has been retaliation.
I'm going to give you, ma'am, you be quiet.
Yes, sir.
So I'm going to pass the matter. Mr. Taylor, I'm going to put you and your client into a breakout room and let you try to figure out what you two want to do. But if she wants to come here and tell me how I'm going to run this, she's got another thing coming. Court's going to stand in recess.
What the hell is a breakout room?
I'll just call you.
The 14A District Court for County of Washtenaw, State of Michigan is now back in session. All those having business before the court draw near. The Honorable J. Cedric Simpson presiding.
All right. I'll come back to the case in a moment. Recalls the case of Wineburger versus Cotterman.
I'm here, sir.
Ready, Your Honor. Your Honor, Ms. Wineburger would, she proposes getting a plumber to come in and fix the problem without, and she don't think she needs to have the tenant to move. In fact, she hadn't received any money from this apartment for the last 3 months, and she's on a financial hardship right now. And she believes she can have the problem fixed without Ms. Cotterman leaving.
Okay, so my question, if that's the case, Ms. Cotterman, are you here?
Yes, Your Honor.
All right. So my question then, counsel, if that's the case, when I signed the order permitting entry onto the premises, why didn't it get repaired?
Well, she was under the impression that Ms. Cotterman was going to leave because the lease was up, Your Honor.
Okay. No, counsel, she filed a motion before this court prior to any hearing date on the possession issue, because that was going to come up. You guys filed the emergency motion.
Because of the water.
Okay. Then the emergency motion, whether she was leaving or not, I granted you authority to enter the premises. And particularly the order indicates to repair the plumbing problem with the bathtub and toilet on July 5th. And that was at a hearing that I had on July 1st. I'm now here on July 8th, after the plaintiff has been permitted entry into the premises. And it's not repaired. And then you're coming to me now, indicating to me that she'll repair it. So I'll be honest with you, I have no other conclusion can I reach that other than that the unit was not, the water was not repaired and restored to the premises intentionally.
Sir, I'm asking to do minimum repairs to get water on because it's going to take extensive.
I don't know why your client keeps interrupting.
Well, she's trying to explain her situation, Your Honor. It's going to cost quite a bit of money to get it repaired because it has extensive damage. She said she could temporarily repair it where the tenant.
Well, why wasn't, if that's the case, then why wasn't that done on the 5th?
She was under the impression that she was going to be leaving because the lease was over.
No, she was under the impression that what she was going to do is force her out by not repairing the water. And she went there just to prevent any damage, I'm presuming. But you can't leave tenants without utilities. And so my conclusion is that when they came in on the emergency motion, there was no intent upon fixing the premises.
She was going to fix it, Your Honor. She didn't know the extent of the damage. And in order for her to fix it, he's got to take the wall out because she did not find the leak. It's in the wall.
I have no report that indicates that. I have nothing that indicates that. I just know that my order indicated, and it was the request of the plaintiff, that she be granted permission to get into the property. I granted that on basically over the July 4th weekend. And she didn't do it. I granted permission to go in to make repairs. Are these licensed plumbers even?
Ms. Weinberg?
Yes. Yes, they are.
I'm just going to tell you the other information that was sent to me by Ms. Cotterman is that on the 5th, which was the day she was to enter the premises, she's claiming that they were non-workers, but it had water flowing out of the faucets, no issues. And before she leaves, she had the water shut off again. She then, according to Ms. Cotterman, she tried to reach her by the number she has, by text, and by email, and got no response from Ms. Weinberg.
We could not find the leak, and I have not heard from Ms. Cotterman.
The obligations of a landlord are that you cannot, voluntarily or otherwise, interfere with the utilities such as to cause an inhabitable condition. It is, and you have an obligation to make the repair upon notification of the repair. I don't know what's gone on between the two of you, and it really is irrelevant to me as to whether or not you two can talk to each other, whether you hate each other. It just doesn't matter to me. That is your obligation, Ms. Weinberg, is to make these repairs. You then, apparently this has been going on for a while. I don't consider placing an individual at a hotel miles and miles from where she resides and or works as suitable accommodations when in this area there are hotel rooms that are available. And so at least from, and this is what the court is going to order today, and I'll give you a new hearing date of I'm going to adjourn this matter to August 5th, 2022, 9 a.m., or as your Zoom invite indicates. But in the interim, I am going to order, I believe that you've intentionally interfered with the premises. I believe that when you came to the court, I ordered it on the 1st. It should have been fixed. It was not fixed. I believe that actually it may be for a longer period in time that you have interfered with this tenant's ability to reside in the premises and failed to fulfill your obligations as a landlord. So I'm going to order the maximum allowed under the statute. Every day is an occurrence. And so that's $200 a day for interfering with this tenancy, whether you'd like her being there or not. And I'm only going to calculate it at this point from the 1st, and that's $1,600. And it's going to be $200 a day until you get that water restored on the premises. I'm not going to even order that you put her someplace at this point in time. You are to get that premises fixed. And it is $1,600 a day. It will click up at $200 per day. The court is also reserving the right to go back to the time that this tenant has been without water after I have an evidentiary hearing regarding that water, because from my understanding, it's been off prior to Memorial Day. And as I indicated before, that's going to total probably darn near another $6,000 in just the statutory damages. I want that water back on. And then I don't even need to figure out why you guys hate each other. Then we can deal with the possession issue. But I'm not going to be used as a tool. This court won't be used as a tool to evict a tenant where this court believes that the landlord has resorted to self-help by failing to provide the utilities that would be required. That's the order of the court.
Excuse me, Your Honor.
August 5th.
Excuse me, Your Honor.
Yes, ma'am.
So I have a problem with the Sarah application because she told Sarah that I don't live here, and I clearly do. That my utility is attached to Sarah, so they are not being able to be paid because of all this going on, and it's going to be shut off soon.
When is the utility shut off?
The 13th of July.
Well, I'm going to put it this way. Aaron, does her account indicate that the landlord said she doesn't live there?
I can't tell. It's with Washtenaw.
Okay. All right. So it hasn't been paid out in any event.
Correct.
All right. Well, here's the way I'm going to look at this. If that's what was said, which would be, quite frankly, consistent with how, or at least the justification that the plaintiff now gives as to why she did not fix the water because she believed that she was moving. I don't know why, if that's the case, and she's told the court that she wouldn't have told Misha that. And that was the defendant's way of getting her utilities paid. The court may very well determine that that is also an interference, which would justify, again, the $200 per day. So here's what I'm going to suggest. I'm not going to make a ruling on this. You said it's off by the 13th?
Sir.
That's their shut off?
Yes.
So, well, let's do this then. I will keep the August 5th date, but I'm going to add a date for a status on, is that your whole DTE bill?
Yes.
I'm going to set that for July 15th, 2022 at 9 or at 1 p.m. So there are 2 hearings now set. The only thing I'm going to deal with on the 15th of July is the DTE. I'm just going to give this one admonishment to the plaintiff. I believe that you stopped her Sarah funding from coming through, saying she wasn't going to leave, which means they're not going to pay her utilities. So if on the 13th, those are shut off, I will start calculating an additional $200 per day for interference with this tenancy. I would further indicate that so your choices are going to be that you talk to the folks at Sarah so that utilities don't get shut off, or pay it yourself.